Question 641. To be enforceable, a buyer representation agreement does not have to A. Be written, B. Include a legal description of the property, C. Be signed by the buyer, D. Include a termination date. Correct answer is B. Include a legal description of the property. A buyer representation agreement is a contract between a buyer and a real estate agent outlining the terms of their working relationship. To be enforceable, it typically needs to establish the agency relationship and the obligations of both parties. This generally requires A. Be written. In California, like many other states, agency agreements for real estate transactions must be in writing to be enforceable under the statute of frauds. This protects both the buyer and the agent by clearly outlining the terms of their agreement. C. Be signed by the buyer. The buyer, as the principal in the agency relationship, needs to sign the agreement to indicate their consent to the terms and their commitment to working with the agent. D. Include a termination date. A definite termination date is important to establish the duration of the agreement and prevent it from continuing indefinitely. However, a buyer representation agreement focuses on the buyer and their search for a property. It doesn't necessarily need to include a legal description of the property because the buyer hasn't yet identified the specific property they intend to purchase. The agreement governs the agent's representation of the buyer during their property search, regardless of the specific properties they might consider. Once a specific property is identified and an offer is made, that property will have its own legal description in the purchase agreement. Question 642. Even if a loan application is rejected due to information included in a credit report, the borrower does not have the right to the following to be A. Notified of the reason why his loan was denied, B. Informed of all information about him, including the sources, from the records of the credit reporting agency, C. Have a second chance, within 1 month, to apply for the loan, D. Informed of all creditors in the last 6 months who have received a copy of his credit report. Correct answer is C. Have a second chance, within 1 month, to apply for the loan. Even if a loan application is denied based on credit report information, the borrower has certain rights protected by the Fair Credit Reporting Act, FCRA. They must be informed of the reason for the denial, and can access a free copy of their credit report annually to see the information used in the decision. Borrowers can also learn who viewed their credit report in the past year, but not the specific creditors who received a copy. However, the FCRA does not guarantee a second chance to apply for the loan within a specific time frame. The lender may choose to reconsider, but they are not obligated to. Question 643. Someone who can execute a valid will is said to have A. Willfulness, B. Pledging power, C. A promissory note, D. Testamentary capacity. Correct answer is D. Testamentary capacity. While a person making a will does so intentionally, willfulness, in a legal context often refers to a deliberate or intentional act, sometimes with a negative connotation. It doesn't specifically describe the legal ability to create a valid will. Pledging power is related to the ability to offer assets as security for a loan or obligation. It's not relevant to the capacity to make a will. A promissory note is a written promise to pay a specific sum of money to another party. It's a debt instrument and has nothing to do with the ability to execute a will. Testamentary capacity is the legal term that refers to a person's mental ability to understand the nature of their actions, the extent of their property, and the identity of their beneficiaries when they make a will. To execute a valid will, the testator, the person making the will, must possess testamentary capacity at the time of signing. Question 644. A buyer may rescind a purchase contract for a property for after entering into the contract. A. 1 day, B. 3 days, C. 10 days, D. There is no right to rescind a purchase contract. Correct answer is B. 3 days. The statutory right to rescind contracts runs for a 3-day period beginning from the date the contract is agreed to. Question 645. Randy has a mood disorder which can cause him to act severely irrational. During one of his manic episodes, Randy is convinced by a telemarketer to enter into a contract for a timeshare property. The contract is A. Void, B. Voidable, C. Valid, D. Modifiable by a counter offer. Correct answer is B. Voidable. A timeshare is a shared ownership model of vacation real estate in which multiple buyers own the rights to use the same property at different times in a year. A contract entered into by a person who lacks the mental capacity to understand the nature and consequences of their actions at the time of contracting can be considered voidable. Randy's severe irrationality due to his manic episode suggests he may not have had the requisite mental capacity to understand the timeshare contract he entered into with the telemarketer. A contract is typically considered void from its inception if a party is deemed legally incompetent at the time of signing, e.g., adjudicated insane. While Randy's manic episode caused severe irrationality, it doesn't automatically equate to a legal declaration of incompetence that would make the contract void. Given Randy's state of severe irrationality due to his mood disorder during the contract signing, it's unlikely the contract would be considered valid. A key element of a valid contract is the mutual assent of parties who have the capacity to contract. A counter offer is a response to an offer that changes the original terms. This scenario describes a situation where one party's mental capacity to enter into the initial agreement is questionable, not a negotiation process involving counter offers. Therefore, because Randy's mental state at the time of the contract could be argued to have impaired his ability to understand the agreement, the contract is likely voidable at his option once he regains capacity. He would have the right to disaffirm, cancel, the contract. Question 646. An effective listing interview between an agent and prospective client should A. Be standardized to cover every kind of property, B. Focus mainly on the licensee's selling achievements, C. Be specifically tailored for each particular property, D. Focus mainly on the licensee's career achievements. Correct answer is C. Be specifically tailored for each particular property. A standardized approach will likely be too generic and won't address the specific selling points and challenges of the client's property. It might not impress the client that the agent understands their unique situation. While past successes build trust, an interview overly focused on the agent's achievements may neglect the client's specific needs and property details. The focus should be on how the agent's skills and experience will benefit this client and this property. Each property is unique, with its own features, location, condition, and market position. A successful listing interview should focus on the specifics of the seller's property and the relevant market conditions for that type of property in that area. This demonstrates the agent's understanding of the client's specific needs and the nuances of selling their home. Question 647. A property estate is granted by John to Bob, for the life of Ruby. The three go fishing and Bob dies in a hurricane, while John and Ruby survive. The estate A. reverts back to John, the original owner, B. no longer exists, C. has its ownership decided by a judge, D. vests in Bob's heirs. Correct answer is D. vests in Bob's heirs. The estate granted is a life estate pure autre vie, meaning, for the life of another. Bob's ownership interest is measured by Ruby's life. Bob has the right to possess and use the property until Ruby dies. When Bob dies, his interest in the life estate passes to his heirs. They will hold the property until Ruby's death, at which point the life estate terminates, and the property typically reverts back to John, or whomever John designated as the remainderman. Question 648. The following statements regarding a broker's trust account are true, except A. Trust funds received by a broker must be deposited in a trust account. B. Trust funds cannot be deposited into an interest-bearing account. C. A minimum balance is not mandatory. D. Trust funds cannot be deposited into an account also containing rental income and security deposits from broker-owned properties. Correct answer is A. Trust funds received by a broker must be deposited in a trust account. Trust fund amounts do not have to be deposited into a trust account. They may also be paid directly to the seller or deposited into escrow or another neutral account. While depositing trust funds into a broker's trust account is a common and often required practice to safeguard client funds and prevent commingling, there are exceptions. The buyer and seller can provide written instructions for the funds to be handled differently, such as direct payment to the seller or deposit into an escrow account or another neutral third-party account. The key takeaway is that while a trust account is a primary mechanism for handling client funds, the parties involved in the transaction can provide alternative written instructions for the deposit and handling of those funds. Question 649. Before a real estate license is renewed, it is required to complete hours of approved courses within a 4-year period. A. 15, B. 25, C. 45, D. 100. Correct answer is C. 45. The California Bureau of Real Estate requires real estate licensees to complete 45 hours of continuing education every 4 years in order to renew their license. These courses cover various mandatory topics like agency, ethics, fair housing, trust funds, and risk management, as well as elective topics in consumer protection and consumer service. The renewal application cannot be submitted to the BRE more than 90 days before the expiration of the license. Question 650. A potential real estate buyer without a real estate license can do the following. A. Negotiate directly with a seller. B. Make a secret profit. C. Deposit funds with an escrow agent. D. All of the above. Correct answer is D. All of the above. A buyer does not need a real estate license to negotiate the terms of a purchase directly with a seller or their agent. Buyers have the right to represent their own interests in a real estate transaction. There is no law preventing a buyer without a license from attempting to purchase a property at one price and then immediately resell it for a higher price without disclosing this to the original seller. However, this scenario is more relevant to investors and flippers acting on their own behalf, not as licensed agents. Buyers routinely deposit earnest money and other funds with an escrow agent as part of a real estate transaction. This is a standard practice to ensure the funds are held securely until all conditions of the sale are met. A real estate license is not required to deposit funds into escrow as a buyer. Therefore, a potential real estate buyer acting on their own behalf, without a license, has the right to negotiate, can potentially make a profit, though ethical considerations apply, and is a party who would typically deposit funds into escrow.